All right. Well, good morning, everyone. And thank you so much for being here for our Landlord Tenant Basics Game Show edition. My name is Ana Maria Studer. I'm the Advocacy Support Program Manager here at Standpoint. This webinar is being recorded, and the link to the recording will be emailed out to Standpoint Legal Advocates listserv later on. It's going to be added to our YouTube channel and website as well. For today's presentation, I'm going to put in the chat box the link for the PowerPoint, so that would be easier to follow along. My role today is to help facilitate the webinar. If you have questions during the presentation, please type your question in the Q&A tab, and I will pass the question along. Most of you probably already know about our organization already, but for those that will listen to this webinar later, or those that don't know, Standpoint is a statewide organization. We are a team of attorneys and advocates working to assist individuals who have experienced domestic violence, sexual violence, or human trafficking when it includes domestic or sexual violence. We also provide assistance to system professionals who work with survivors. We do this by facilitating trainings and answering calls through our action line. Examples of the trainings that we provide are the new laws trainings that we do throughout the state of Minnesota every year, the monthly webinars like the one we're offering today for advocates, and other trainings by request. Our action line is answered Monday to Friday from 9 a.m. to 4 p.m. And it's through our action line that our attorneys provide legal advice to survivors, and our advocates connect callers with resources. We do safety planning, listen and help callers identify possible options and next steps. Now I'm going to introduce our amazing housing team composed by Ann McFarland and Raylene Caswell. Ann is our staff attorney and supervised attorney here at Standpoint. Ann joined Standpoint in March of 2020. She's a graduate of Mitchell Hamlin School of Law and has focused her legal work on housing law, landlord, tenant law, and has experience in providing legal services to underrepresented individuals, providing advocacy to victims of sexual violence, and training and supporting volunteer attorneys doing housing work. As a housing attorney for Standpoint, Ann provides legal advice and consultation on legal issues affecting victims of domestic and sexual violence. Raylene Caswell is our housing advocate and supervising advocate. Raylene, pronounced she, her, began her work as an advocate in 2009. She has focused on housing stabilization, crisis intervention, shelter work, hospital-based advocacy, program development, and volunteer management. She's passionate about promoting the wellness and resilience of advocates in the field. And now I introduce with great pleasure our housing team, Ann and Raylene.
Wow, thanks for that, Ana Maria. We're glad you're here with us today to help us out. All right, so to kind of jump in, today's presentation is going to be a game show edition, and you're going to have to roll with us on this one. We wanted to make it a little more fun than a regular kind of webinar, so it's going to be a lot of hypotheticals, lots of questions at the end, and hopefully some fun. We're hopeful for that. So we're going to go through, like I said, we'll have lots of legal info, some stuff you might already know, some stuff that might be new, and hopefully you'll learn a thing or two. Do lots of hypotheticals, so we're hopeful that you'll throw some answers in the chat, the Q&A, things like that, so that we don't have to just stare at our screens for a little while, because we will. Anne is very good at that. And then we'll do some quizzes at the end. So with that, we will kind of jump in to our presentation today.
Okay, so we're going to start with the definition of a residential tenant. So a lot of people, this is actually a common issue that we discussed on the action line. The answer isn't clear. A lot of people are surprised to learn that they are actually either a tenant or a landlord. This comes up all over the place, not just with domestic violence situations. It can be like parent-child, domestic partners, friendships. Anytime you have someone where you allow them to stay, if you're an owner and you allow them to stay in your house for a while, they can, inadvertently mean that you've established a landlord-tenant relationship. When we are talking about this on our action line, the situation is usually that one person in the relationship, and we see it often where it's the abusive party, but sometimes it's not, where the abuser owns the property and then has a partner who lives with them, even though the parties did not intend for it to be a landlord-tenant relationship. The law says, well, depending on the facts, right? The law might say that it is actually a landlord-tenant relationship. So the arrangement, either way, the arrangement creates this substantial power imbalance, because when only one person is owning the home and the other person is staying there, that person now who owns the property has control over the other person's most basic need, right? That need for safe and stable housing. And we often talk to people who have been living together for years. Sometimes then the victim will come home and just be locked out of the house and think that there's nothing that they can do. But actually, there is, because they might be entitled to tenant protections. So the statutory, and this is where the confusion comes up. The statutory definition for residential tenant, it means a person who is occupying a dwelling in a residential building under a lease or contract, whether oral or written. So all that sounds normal so far, right? Like, hey, there has to be an agreement that one is paying rent and, the other person, is a landlord. But then it has this phrase, all other regular occupants of that dwelling unit. And that's the part that opens up this question about who is a tenant, and who's a landlord, depending on how we're looking at it. So that phrase there, all of the regular occupants of that dwelling unit, it's an ambiguous, it's kind of a catch-all. So there's been, case law about it where the courts have just said, we're going to look at the facts of each case to determine whether we think it's residential tenant or not. So the gist here is, Raylene and I joke about this a lot. Don't have anyone sleep over because you might become a landlord. Obviously, that's extreme, but the gist of this is, when you're working with victims, whether they own the property or are staying with someone who owns the property, we might think if the victim is the one who doesn't own the property, we might think that the victim doesn't have any options, but they more than likely do. The flip side of that is, if you're working with a victim who owns property and there's been domestic violence, a lot of times the victim is like, well, it's my house, I want to just change the locks. And that can open that victim up to legal liability under an illegal lockout statute. Did I get everything, Raylene? Do you think, did I miss anything?
Yeah, I think that's good. So I think that, like Anne said, the gist of it is that it's kind of complicated, and you could be a surprise landlord or a surprise tenant, and there are pros and cons to that. So with questions, or if you're wondering about that, just call.
Yeah, and most of the time, if you're dealing with this situation, if you call law enforcement, the vast majority of law enforcement is going to say you have to let them back in the house. You need a court order to remove someone from the property.
And Anne, we did get a comment. Your audio is a little bit hard to hear. So perhaps we can take a look at that. We'll do our best. Maybe get real cozy with the computer.
I know, I have to get really close.
Hopefully that's better, but keep letting us know. Thanks for that.
Yeah. So then we're gonna talk a little bit about different types of tenancies. There are various different types, right? But these are the most common. We're going to talk about notices that terminate the tenancies next. But always remember that with any kind of a tenancy, written notice is always required. The timeline and everything changes for every type, but written notice must happen is required to terminate a tenancy. So the first kind and the most common type is a fixed term tenancy. And a fixed term tenancy is when you have a written lease agreement and there's a start date and an end date. So that's a fixed term. I suppose you could have a fixed term oral tenancy, but that would be hard to prove. So, most of the time, if you have an agreement to move out, say on June 30th, but it's not in writing, that's not going to be enforceable really as a fixed term tenancy because of lack of proof of it. We have a tenancy at will, which is just a rental agreement without a fixed term, right? So there's no specific end date. We commonly refer to these as month-to-month lease, and usually we see these when there is no written lease. And then we have what we call a holdover tenancy. And this is when a landlord has given appropriate notice, depending on the type of the tenancy and the notice period required. So the landlord is given notice to terminate that tenancy or a notice to vacate. Sometimes they're called a notice to quit. But it doesn't matter what we call it. If the landlord is given written notice with an end date and the tenant stays in the property after that end date, the tenant now is considered a holdover tenant. Really, did I miss anything here?
I don't think so. I think just knowing about the different types of tenancies is important because it will impact your options in terms of, giving notice and things like that. And just, it's good to have an understanding of what's going on so that you can make good choices going forward. That's all.
Right. And I think one thing when we talk about like the previous slide, when we are like inadvertently become a landlord or tenant, right? Those are typically going to be considered tenancy at will because it's a rental agreement without a fixed end and without a fixed period. So those are most likely tenancies at will. It's also important, we get calls about this a lot. Landlords will often, well, not often, sometimes decide that they're done with, for whatever reason, and they give someone a notice and they say, you need to be out in a week. Or they just tell them you need to be out. And that's not legal. Landlords cannot remove someone from the property without a court order. So the only way for a landlord to legally remove someone from property is to have a court order. There are statutes or penalties for landlords, this unlawful exclusion or removal. There are penalties there, and different statutes have different penalties. But if you're working with someone and they're saying the landlord said I have to leave, you can know that's not legal. There has to be a proper notice depending on the type of tenancy. And then if the tenant doesn't leave or doesn't move out voluntarily, then they'll have to go get a court order, which means they have to file an eviction.
And there is a question from Christine, is if there is a verbal agreement for tenancy at will, does the landlord also need to give written notice to vacate?
Yes. A notice to vacate always has to be in writing. It doesn't matter what kind of tenancy it is.
And then we have a question, and perhaps we get to it later, but what constitutes proper notice, and does proper notice differ? We get to that in a little bit, so we'll get there.
Yeah.
Oh, and can you go back once? Can you talk to us about the termination of utilities? What does that mean, and how does that exclude someone from the property?
Okay, so an unlawful exclusion or removal, we call illegal lockouts. And an illegal lockout can be like an actual one where they change the locks, right? But there can be what we call constructive lockout. So if the landlord turns off the utilities, or if the landlord, if locks are broken, and so then someone can't go in, anything that happens in the property that makes it so that the tenant can't really live there safely, that can be considered a constructive lockout. So if the landlord turns off the water, or if the landlord, turns off the heat or anything, it makes it the condition of the property kind of unlivable. That would be considered a constructive lockout. We can use, this when victims need a lock change and the landlord is refusing, then we can argue, we would file a rent escrow claim, but also include an illegal lockout or an unlawful exclusion claim on that. Because, having locks that are compromised could be considered a constructive lockout. So we're going to do some hypos quick, but just to let everybody know, we are going to talk about the notice periods and how to give notice and everything.
So first, we'll read through the question, and then we'll launch a Zoom poll so you can answer. But Hypo 1 is that Jackie purchased her home in 2005. She is the only person on the deed and mortgage. In 2015, Jackie and Sam began a romantic relationship, and Sam moved in with Jackie later that same year. The two lived together, sharing living expenses until now. In the beginning, the agreement was that Jackie would pay the mortgage, Sam would pay some of the utilities, and they would share the rest of the daily living expenses. Now, years later, the two contribute to all living expenses as needed with no specific pattern. After several incidents of domestic violence committed against Jackie by Sam, Jackie is ready to end the relationship and she wants Sam to leave the home. So we have 2 questions for you on this one, and you'll hopefully see that in the Zoom poll. So first, is Jackie a landlord? And the second question, can Jackie tell Sam to leave and change the locks because she's the only one on the mortgage and deed? We'll give just a few seconds here for folks to muddle through that a little bit, because we muddle through these questions a lot. All right, we'll do 10 more seconds. So lock in those answers. All right, so sharing results. So first question, is Jackie a landlord? Yes. That's the answer. Most of us got that right. Excellent. And then the second question is a little more confusing. So can Jackie tell Sam to leave and change the locks? And what do you say?
Oh, no.
Oh, you're all right. We had the wrong answer on that one.
We did? That's terrible.
We're gonna do
okay. All right.
So can Jackie tell Sam to leave and change the locks? Yes or no?
No, that would open her up to liability for under an illegal lockout claim. Now with this one is a little bit tricky because as we talked about, this is sort of a gray area. Here in the cities, for sure, Jackie would be considered a landlord. In more upstate, I have seen judges dismiss evictions in cases like this, saying this is not a landlord tenant. But I've only seen that once. I think the majority of the courts around the state are going to say this is landlord tenant and give tenant protections. But generally speaking, no, we don't. We would want to go forward like as though Jackie is a landlord in order to protect Jackie from other legal action.
Sweet. Well done, team. Next hypo. So this one is similar questions here. So Diane has been with her partner Jack for the past 22 years. After 2 years of dating, Diane moved into Jack's home and she has lived there ever since. Diane and Jack split monthly bills, including the mortgage, but Diane's name is not on the mortgage or deed to the property. Jack has been emotionally abusive for a long time, but last month he physically assaulted Diane, and she has recently been talking to an advocate about safety planning as she prepares to leave the relationship. Yesterday, Jack changed the locks on the doors while Diane was out running errands. So we have a few questions for you. Pull up the poll here. So is Jack a landlord? Can Jack force Diane to leave the home and change the locks? And does Diane have a legal financial interest in the home? Everyone is all on the same page here. So I'll give 10 more seconds and then we'll check our answers. Hopefully we answered them correctly too. All right, so is Jack a landlord? And what do you say?
Probably yes.
Okay, and is Diane a tenant?
Probably yes.
All right. And can Jack force Diane to leave the home and change the locks?
No.
And we were a little struggling with this one. Does Diane have a legal financial interest in the home because she has been paying half the mortgage and upkeep and daily expenses in the home for the past 20 years?
This one is tough. It's probably no. I think if the courts determine this is a landlord-tenant relationship, then they're going to say that her paying half of the mortgage is her paying rent. This could be one of these things where if Diane like contributed a lot of money to improvements in the home and different things like that, then she might have a different kind of claim. But without a really specific agreement that, you know, she's paying into the mortgage to, and and Jack is giving her, you know, some kind of claim to the equity in the home, it's probably going to be considered more of a rent payment.
And
I'm
just
wondering, does anyone catch the reference? See, I'm aging myself here.
I picked
With
the
Jack
names.
and Diane. You what?
I picked the names. I was hoping someone would enjoy that.
Did anyone? Oh, okay.
I don't know. And then one question for you, Anne. If Jack and Diane were married, does that change the legal financial interest?
For sure. Yeah.
Great. So yeah, that's a big piece. So if you're working with folks, you got to find out if they're married or not, because that is it's complicated for sure.
Yeah. Even if they were married, if they got married 2 years in, right? Then Diane has a marriage. She may not have like a legal interest in owning the property, but she has a financial marital interest in the equity of the home.
Cool. All right, next typo, and then we'll do some more chatting through things. This one's a little bit longer, so bear with me. So Miranda has been dating George for about a year. For a year. About 9 months ago, Miranda invited George to stay overnight. He gradually started staying overnight more frequently and eventually got to the point that he moved in some of his belongings and wouldn't leave. For the past 6 months, George has stayed at Miranda's apartment almost every night. Miranda has asked him to leave because she is worried her landlord will notice that she has someone staying in her unit that isn't on the lease, and he refuses. Throughout the relationship, George has been controlling and emotionally abusive. Last week, George became physically violent and Miranda called the police. When the police arrived, Miranda told them she does not want George to be arrested, but she does want George to leave her home. The police asked how long he had been staying at her apartment and if he received mail there. Miranda told police that George had been staying there for almost 6 months and that he does receive mail at her home. The police informed her that because he has been there longer than 60 days and receives mail at her home, he is a resident and cannot be removed. So let me get the poll launched here for you, and you can tackle the next set of questions. And while folks are answering, Anne, we do have a question in the chat.
Okay.
Is there some sort of no nuptial, I don't know how to say that word very well, agreement couples can sign and legally put into place where Diane's money toward the mortgage would give her financial legal interest in the home? Asking in the case a couple is not married but wants to agree to share interest in the property.
No, the best way for anyone to share interest in the property is to add them to the deed. Does that answer it?
I don't know. We'll wait for our friends to
Yeah.
Katie, if it answers your question, let us know. Otherwise, yes, it does. Fantastic.
Okay. Yeah, add them to the deed.
Perfect. All right. So we'll end this poll here in just a few seconds. I see some other answers sliding in. All right, and closing the poll now. So first question. Let's see.
Is there a way to show the answers or show the responses?
They are,
Or we just go back.
I didn't check the box. I don't know if it's showing it, but we'll answer them.
Yeah, okay,
So
that's fine. Yeah.
in the beginning, or the first question, is the officer correct? Is George a resident because of his length of stay at the home and mail?
So the answer, I mean, if it reads No, George is probably a tenant, so yes, for other reasons. But no, the officer isn't correct in his reasoning. So I think for this one, we would say yes for other reasons or no.
Yeah, and we wanted to put that in there because that's often a question that law enforcement asks, is like, how long have they been there? And they I don't know, they seem to have different lengths of time
Yeah.
and ask about the mail. I don't know why mail is so important, but those are things they rely on. But
yeah, we get calls where like law enforcement relies on different factors like that. And that's not to say that law enforcement. So the general rule is like if someone has been staying there, then they probably fit into that category of all other occupants, right? In the residential tenant definition. Law enforcement agencies, I suppose, can have their own policy about what questions they ask or anything like that, but that's not anywhere in the law.
cool. All right, so our next favorite question is George a tenant?
Yeah, probably.
Again, it's a confusing one because he's not on the lease and things like that, but most likely, yes. And then the last one, should law enforcement force George to leave the apartment, assuming that he is not arrested?
No. So we don't, law enforcement isn't in the position of making a legal determination about whether someone is a tenant. So that is a question for a court. So that's why law enforcement will almost always say, no, you need a court order because they can't decide. Law enforcement isn't there to interpret the facts or the law that way.
Let's see, we do have a question about 30-day residency and we're going to get to that.
Yeah.
We're going to get there, promise. Mm-hmm. All right, moving on. All right,
okay.
So go ahead.
Sorry. Mm-hmm. So now we're going to talk about how to terminate those leases. So we really wanted to get the point across that more often than not, there are landlord-tenant relationships, even when people don't mean for that to happen. And then we wanted to really point out that if there's a landlord-tenant relationship, you can't just have somebody leave. You have to go through the legal process. And the first thing to do to terminate a tenancy is to give a proper notification. So when we also really like to point out, if you have a fixed term tenancy, so a start date and an end date, or you have a month-to-month tenancy, the law is pretty clear that either party can choose to terminate the tenancy for no reason. We get calls a lot where the tenant, is angry because the landlord has decided to terminate the tenancy, and they do it according to the law and everything. But a lot of people think that the landlord has to have a reason to terminate a month-to-month tenancy or a fixed-term tenancy. Now, there are some cities that have ordinances that might have around this kind of stuff, but the general rule is no. They don't have to have a reason. They can't do it retaliate or give a retaliatory notice, which is a different issue that we'll talk about. But the general rule is the landlord doesn't have to have a reason. So written notice is always required, both the landlord and the tenant. So if you're a tenant and you intend to terminate and move on, then you need to give that notice. For a fixed term lease, we need to look at the original lease agreement to see what the notice period is. If it's a month-to-month lease, we have to give one full month notice. And so there is no 30-day notice. It's a full month notice. So some months are 28 days and some months are 31 days. And so we generally interpret that as meaning one full calendar month. So if you give a notice to terminate on March 31st, the move out date, the vacate date would be April 30th. If you give the notice on April 1st, now April has started, they need a full calendar month. We're talking of a move out date of May 31st. Again, no reason is required. There are certain exceptions, public housing, project-based Section 8, they have separate rules, but generally speaking, no notice is required. And then Also know that a notice, a written notice to terminate is not an eviction. So we get a lot of calls where people are kind of panicking. They're saying, I'm being evicted, and it's because they have the notice. A notice to vacate is not an eviction. It doesn't mean you're going to have an eviction record or anything like that. It's just the standard procedure for terminating a tenancy. The key thing here is if a tenant remains in the property after the date provided in that the notice to vacate or the notice to terminate the tenancy, remember then they become a holdover tenant. And then if a landlord has a holdover tenant, they can go file an eviction based on holdover.
And I think too, when we're talking with folks, a lease termination, notice to quit, non-renewal, whatever you want to call it, or whatever's going on, still feels like an eviction. Like the paperwork is different, but it still feels scary because their housing is ending. So it feels the same, but our responses to an eviction versus a termination are different. So it's important to find out what is happening. Because if it's an eviction, you want to connect with legal aid, you want to do, or call us or whatever, make sure they're going to court and getting all that taken care of. If it's a termination, spend effort looking for new housing, because that lease is going to end. So that's the only thing that I wanted to add for that.
But for a notice to be valid, it needs to be in writing. It needs to give a very concrete, a specific move out date, and it needs to be dated. So the letter, it has to be dated. An email is dated with the timestamp, so that counts. I don't recall if we talk about retaliation later, but a landlord can't give, or a notice would be presumed by the law retaliatory if it is given to the tenant within 90 days of the tenant exercising their rights. And this is important for us. If we have a tenant who is a victim of domestic violence, and then within 90, and maybe law enforcement is called to the property because of it, and then within 90 days, the landlord gives a notice, even if it's a month-to-month tenancy, or even if the fixed term lease ends, if the notice to terminate comes within 90 days of an incident like that, the tenant can argue that is a retaliatory notice. There's a presumption of retaliation. Retaliation, it's good and it sounds good on paper, but the reality is, as long as the landlord convinces the court that they have another reason to terminate, like I need to upgrade my property, or I don't want to rent this anymore, or something like that, then that presumption can be pretty easily shut down. So this is just putting this all together in one place. So going forward, you'll have these slides, and if you have questions about it, you can come back. It talks about the fixed term tenancy and the tenancy at will and the holdover tenancy, and it gives the details for that, for each one. One thing to note, if a fixed term tenancy says 30 days or 60 days, that doesn't have to be a full calendar month, right? It would just be, the notice would be 30 days or 60 days. But with the tenancy that will, that's where we for sure and look at making sure we have a full calendar month for the notice. And again, all of it needs to be in writing. Just a reminder, we get this a lot. Everybody and landlords believe that we do, and it's just not a thing in Minnesota.
All right, so hopefully this is review for folks, but if you don't know, Minnesota has a statute allowing victims and survivors of domestic violence, sexual extortion, and harassment to break their lease due to fear of violence. And this is a really awesome thing for folks to get out of places that they might not be safe in, whether the person that they're afraid of lives with them or just knows where they live or they just don't feel safe there. So this process is pretty easy, it's pretty simple, and it's really great, and advocates can help with this all the time. The basic way that it works is that the victim survivor would turn in some documentation to their landlord, which we'll talk about in a second, and then they can decide when they want to break that lease, when they want to end that lease, and they don't have to give the normal kind of notice that's either outlined in their lease or by their type of tenancy. So we could break a lease today if we wanted to. And to be honest, it's one of my favorite things to do. So is really nice because it can be so empowering for people to get out of an unsafe home. Once they turn in that documentation to the landlord, they move out, treat it as much like a normal move out as possible in terms of cleaning, turning in the keys, all that kind of stuff. And then the lease is considered broken for everybody. So if there are other roommates or anything like that, the lease is completely ended. And the one big bummer is that you do lose the security deposit. So the security deposit is forfeited. And you do have to pay rent for the entirety of the month that you're there. So if you broke a lease today, you would be responsible for all of March rent. If you broke the lease April 1st, you'd be responsible for all of April rent. So it's nice to kind of sneak it in before the 1st of the month, if possible. Obviously, it's not always possible for folks to do that based on safety needs and things like that. But that's essentially the process. The types of documentation that you can turn in would be an order for protection, harassment restraining order, something like that. Something written, sorry, let me back up. You have to turn in 2 kinds of documentation, one verifying the abuse and one and essentially a notice to the landlord ending the lease. For the documentation for the abuse, you can do that, like I said, an order for protection, harassment restraining order, something from a court official, something from a law enforcement official. To be honest, I've never seen those, and I don't know what that would look like exactly, because that sounds hard to get when we as advocates can write something called a qualified third-party statement. And it's a simple form. The language literally comes from statute, saying that I'm an advocate, I've talked with this person, I have reason to believe that they have experienced violence and are in fear for their safety if they were to remain at the property. And I tend to prefer that one because it's super fast and easy for me to write. It gives the landlord very little information, which is nice because the landlord doesn't need to know what's going on necessarily, and they can turn that in. And that if you need that, we can send checklists off. It's again, the language is right in the statute 504B.206, and that is super easy and simple. The other thing you have to turn in is the notice to the landlord, and we've got that as well available on our website that you can use. You just have to make sure that the like it's dated, all the information is filled out appropriately. And the one biggest thing is that you want to make sure that you're not backdating a lease break. So I can't date it as of yesterday. For example, it would have to be anytime today or going forward. And then you essentially give that to the landlord, and the lease is considered broken by the date that you wrote in that notice. And the other piece to talk about is that the landlord cannot request any additional information. So the landlord can't be nosy. They can't ask, you don't have to share who the person is that they're afraid of or anything like that. And then landlords do have to keep everything confidential. So anything in the notice or qualifying documentation, the tenant's forwarding address, and all of that has to be kept confidential. And they cannot enter any of that information into a shared database. So it's supposed to be confidential, and we want to make sure that that happens. So folks, just so landlords aren't sharing that information for safety reasons to future landlords, things like that. Did you have anything that I missed, Anne?
Yeah, I'm not sure if I missed it, I'm sorry, but we need to talk about co-tenants.
Yeah, so when a lease is broken, in using this statute, the lease is broken for everybody. So if there are roommates or the person who we're afraid of is living in the home, that lease is ended for them. What that means is that the victim survivor can move out and do what they need to do. And the landlord will have to figure out what to do with whoever remains. So that could mean that the landlord, the tenancy would end for the remaining tenants, or the landlord could sign a new lease with whoever wanted to remain there. The landlord could go through their own eligibility requirements and whatever else they got to do for that. But the landlord could continue to rent to any folks that remain. When there are co-tenants, we're trying to fix things and make it better, but sometimes the landlords don't remove the victim survivor from the lease and just kind of continue on with what they're doing. So we always recommend that people are following up and checking Minnesota court records online to make sure that a landlord has not filed an eviction. And I would do that for a little while, a couple of months sometimes, depending on the situation, because we don't want to have an eviction filed on the victim survivor and they don't know about it. So I forgot that point. Thank you so much, Anne.
Yeah, and that does happen quite often where we see victim survivors terminated with 206, and then a couple months later, the landlord filed an eviction, and nobody knows. The tenant victim doesn't know about it because they left the property, and then there's a hearing, and the victim doesn't show up, and then it looks on the court record, it looks like they defaulted. Sorry. They looks like they've defaulted. You know, and like they just didn't show up for a hearing or something, and that just doesn't. Those can be kind of hard to get expunged. The only other thing I would mention is we always tell people if you can email these notices to the landlord, do it via email, because then we have that evidence to show, you know, especially if we need it later to try to get an expungement, or if we find out the landlord files an eviction, then we have proof to go to that eviction hearing and say this shouldn't have been filed in the first place, kind of thing. So we always recommend people give that stuff, the notice and the qualifying documentation via email.
And we do have a couple questions here. So first we'll do lease break questions. So if the tenant is behind on paying rent and breaks the lease, how does that work? Is there a requirement for how fast they must pay the past due rent before legal action can take place? Can legal action take place? Great question.
So yeah, the tenant owes the money, but being behind on rent doesn't prohibit a victim from using the statute to terminate the lease early. So they're still terminating the lease. They just owe the landlord money. So, and when a landlord is owed money, they often throw it in collection. And so even if there's not an eviction on the record, owing a landlord money often will prevent them from getting approved down the road. But you can definitely use 504B 206 to terminate a lease, even if you're behind on rent. You just owe that money.
Sweet. Oh, another one came in as well. When breaking a lease, does the tenant have to move out immediately that day that they send the landlord the lease break?
Sorry. In the notice letter, you state what date the victim states what date they want the tenancy to terminate. A lot of times, Raylene and I will talk about, you know, you can just decide what day you want to move out and give the notice on the same day. As you go, but the victim survivor chooses the date for the termination of the tenancy.
Yeah, and sometimes that's a conversation you're having when it involves safety. You know, maybe the victim survivor lives with the abuser and the abuser is friends with the landlord. You don't want to give the landlord the heads up, because even though it's supposed to be kept confidential, there's that risk there. That landlord doesn't follow the confidentiality rules, and it could put the person at risk. So I could turn in my notice today for April 7th if I wanted to, or I could do that on April 7th. So it really is like you get to be in charge of what that looks like. Sometimes people have great landlords, they love their landlord, have good relationships there, and they want to give them more notice. Sometimes it's March 29th and we got to go now. So it kind of depends on the situation. All right, and then switching modes a little bit.
There is one more question, Raylene. I think it was from what you guys were talking before for the at-will tenancy. If a landlord rents a room and they're home to a tenant and is an at-will tenancy and the tenant is harassing the landlord, can the landlord terminate the lease without the notice?
No, the landlord has to give the appropriate notice based on the law. So if the tenant is making monthly rent payments, then the landlord has to give 1 month notice. There's a possibility that the landlord could get a restraining order, but a lot of times the courts won't remove people from property with a restraining order.
Some will, some won't, and it's complicated. An order for protection, however, is a different story. So in this situation, if the landlord is the victim survivor of domestic violence or whatever might be happening, and they've got an order for protection, that could remove somebody from the home physically. Okay, another one. If the landlord, I'm so glad we're getting all these questions. This is
I know, I love it.
If the landlord follows confidentiality guidelines, does the landlord inform other tenants as soon as the victim survivor tenant breaks the lease, even if the victim survivor is not moving out that same day? This is an excellent question, definitely makes sense. When there are other roommates or tenants, it is complicated. And we're trying to figure out a better way to do it. But Essentially, landlords are not supposed to tell anyone that someone is breaking the lease, and they also have to tell the other tenants that their lease is ended, and they can't really say why. So they're in a tough spot. They're in a really tough spot, and some landlords are pretty strong about it and don't break that confidentiality, which is great. But if my lease randomly got broken and my landlord was like, you got to get out, I'm going to be super mad and I'm going to call an attorney because that doesn't feel fair to me as a tenant. So it's a really tricky spot, and you can probably have better thoughts than me.
Yeah. And in cases where you have co-tenants and we don't really want the co-tenants to know it's happening before the victim survivor moves out, then that would be a place where we would definitely advise, give the notice when on the day that the tenant is vacating the property. But yeah, the law says that when one co-tenant terminates using 504B206 and there are other co-tenants, two things happen. The original lease is ended and the landlord has to figure out either give a notice to terminate the tenancy for the co-tenants or enter into a new lease agreement. So the law says that. The law also says there's confidentiality and landlord can't say anything. So it's a tough spot. Landlords are in a tough spot. We don't have an answer for that.
Yeah. If I'm living with my friends or something, as a victim survivor, I might tell my friends that I'm breaking the lease and give them some notice. But if I'm living with the person I'm afraid of, probably not going to do that. So it really is dependent on the victim survivor and what they want in terms of what they're sharing with the co-tenants. The landlord is not supposed to, but from a legal standpoint, how are they supposed to tell the other tenants what's going on? And they can't. So
yeah, and the other piece of this is that landlords don't necessarily know all the specifics of the law, and the confidentiality requirement doesn't really come with a way to enforce it. So when landlords break confidentiality, there is not a whole lot that the tenant can go back and do for consequences at this point.
And do you see the situation often where the victim survivor breaks the lease and there are co-tenants who have no idea what's going on?
I haven't seen it a whole lot, actually. I have talked to at least one person who I think that's what was happening. Her tenant had left, her co-tenant had left, and then the landlord is telling her she's got to leave and she doesn't know why, and they won't tell her anything. So I suspect that was happening in that one, but I don't see it a whole lot. Honestly, my guess is landlords probably tell the co-tenants what's happening most of the time, but that's a guess, because landlords feel like they're in an impossible situation. So,
and to be fair, most of the time we are the ones helping people break the lease.
Yeah.
So our scales are skewed a little bit in that sense.
Yeah.
Great. These are awesome questions. Keep them coming.
Yeah. Did we get another one, or?
I think that's all of them. If I missed any, please throw it in the chat again. But I think that's everything.
Okay.
I love talking about lease breaks though, so if you have more questions, please call.
Yeah. I think one other thing about the security deposit, the question we get a lot is when there's a balance owed either for back rent or property damage or something, does the landlord have to deduct the security deposit from the amount owed? And the answer is no, they do not. The security deposit is forfeited. Some landlords will deduct it and then charge the tenant for the rest. Others will not, but the law does not require that.
Cool. All right. Moving on. Oh, good. Some more hypos. I know you're all excited for this. So in this hypo, we have Jackie purchased her home in 2005 with a VA loan, Veterans Assistance Loan. I can't remember what it stands for.
Yeah.
She is the only person on the deed and the mortgage. In 2015, Jackie and Sam began a romantic relationship, and Sam moved in with Jackie later that same year. The two lived together, sharing living expenses until now. In the beginning, the agreement was that Jackie would pay the mortgage, Sam would pay some utilities, and they would share the rest of the daily living expenses. Now, years later, the two contribute to all living expenses as needed with no specific pattern. So it's kind of some similar fact patterns as before. But after several incidents of domestic violence committed against Jackie by Sam, Jackie's ready to end that relationship and she wants Sam to leave the home. So a couple questions for you. Can Jackie give Sam a 30-day notice to vacate? And how could Jackie get Sam out of her home? And I'm gonna launch this. There we go. There's only one question there. I don't know why. Sorry. Can Jackie give Sam a 30-day notice to vacate? You guys, these polls are a lot of work. Thank you for bearing with us when they are not perfect. All right, 10 more seconds and we'll close that poll. I don't know why the answers aren't showing up. I apologize. Anne, can Jackie give Sam a 30-day notice to vacate?
No. Did anybody say yes? I hope not. There's no 30-day notice in this.
I'm not telling you.
There's no 30-day notice. Jackie can give a 1-month notice. Oh, that's the answer, part of the answer to the next question. Jackie can give a 1-month notice, a full calendar month, because, you know, they had this arrangement that Sam was paying, helping pay monthly. If in a situation where, like, if there was no agreement and and Sam wasn't helping with monthly stuff, like on a regular monthly basis, then Jackie would have to give a 3-month notice. See, I almost did the days. A 3-month notice. When there's no regular monthly payment, then it's a 3-month notice. But here we would argue that, you know, he paid utilities and doing this kind of stuff. At least that was the agreement in the beginning. We would argue that he's making monthly payments, so then Jackie has to give a 1-month notice. There's another way that Jackie might be able to get Sam out of her home, and I wonder if anyone has any ideas. You can throw it in chat. Raylene, can you see the chat?
I can see the chat.
Okay, good.
Mm-hmm.
Anyone? Yes. Yeah.
Ding, ding, ding.
Yeah. Okay.
Beautiful. Or if he was arrested and charged, a danko. Yep.
Yeah.
Love it.
Protective orders. Yep.
And those are good safety planning measures for sure. So always explore those with folks. It's going to be faster, to be honest. All right, next hypo. So we have Sang, Noi, and Feng are friends who share an apartment. All 3 are on the lease. One night on her way home from work, Sang was sexually assaulted by a stranger. The perpetrator stole her wallet and now has her driver's license. As a result of the assault, Sang no longer feels safe living in the apartment and wants to move. Sang connected with an advocate who provided a qualified third-party statement for her to give to her landlord, along with the notice to end lease due to fear of violence letter, that notification letter. The landlord told Sang that although she believes Sang was attacked, she doesn't think Sang is justified in fearing that danger in her apartment because the attack occurred in a different location. Sang's landlord also said that if Sang terminates her lease early due to fear of violence, the roommates will have to move or be evicted. So we have a couple questions for you, and I'm going to hope that this one is correct. First, does Sang have to explain or prove to the landlord that the perpetrator stole her driver's license and as a result has her address? And the second question, will the roommates have to move or face eviction? All right. Got lots of answers locked in. We're going to keep her moving. So I'm sorry the answers don't show. I don't know why. So first question, Anne, does Sang have to explain or prove to her landlord what's going on?
No. Nope. The tenant, the victim survivor, doesn't have to give the landlord any information other than the notice letter and the third-party statement. That's it. And the roommates will not have to move. Well, the landlord has to go back to the roommates, enter into a new lease agreement, or give them a notice to terminate the tenancy.
And if you maybe want to explain that a little more, we're pretty split on that question. So with roommates, the options are what? The landlord could enter into a new lease with them, or their tenancy would be terminated.
Yeah, so the 504B206 statute, it has in it that when someone terminates with 504B206, the original lease is terminated. So it is terminated, right? So the landlord has to go back and either enter into a new lease agreement with the co-tenants or give them a notice to vacate, and then they'll have to move. And if they don't move out according to that notice, then yeah, the landlord can evict them.
Cool. All right. In the interest of time, should we move on to VAWA?
Yeah, let's do it. Yeah, okay. So the Violence Against Women Act has housing protections in it. And the main purpose of those housing protections is to ensure that victim survivors, they're not denied admission, evicted, or have their housing subsidy or assistance terminated because of the violence that's committed against them. So VAWA applies to federally funded housing programs like public housing, Section 8, tax credit housing, things like that. There's a ton of different programs. Obviously, although it's titled the Violence Against Women Act, the protections apply to anyone who is a victim of domestic violence, sexual assault, dating violence, or stalking. The one thing to note here, though, is that anyone can be evicted for other reasons. So if someone is being evicted for non-payment of rent, and in Minnesota, like 95% of evictions are non-payment of rent, VAWA protections aren't going to apply, right? Because being behind on rent, well, we all know it's the result of domestic violence, but from a legal perspective in housing court, it's not. So these protections apply to like a breach of lease for noise disturbance or different things like that. Then we can use the VAWA protections. I think of this in 3 different categories. The first is when a victim survivor applies for housing benefits to live in a federally funded property. The second category includes these provisions that enable a victim survivor who already lives in the subsidized housing or already has their benefit. They can request things in order to stay safe, like they can request a transfer, they can request to bifurcate the lease to remove an abuser from the property so that the victim can stay in the property, different things like that. The third category is more protections once someone already has their housing benefit, and it protects them against from being penalized for the abuse that they're experiencing. So that would be like lease violations or being evicted or being charged property damage that was caused by the person who has harmed them. The key thing here is in market rate rental properties, VAWA does not apply. It's just federally funded properties. So when we are going to go assert VAWA protections, we certify as a victim survivor. Sorry, Raylene, this is usually you. Do you want to?
Sure, I'll jump in. So if anyone is in federally funded housing and wants to, like Ann said, assert any of those protections or rights or whatever, people often call about their VAWA rights as kind of how they phrase it. They would have to certify as a victim survivor. A landlord can, like it says here, accept a verbal certification, but often require it to be written. And to be honest, sometimes it's just nice to have it in written form and sent via email and all of these lovely things anyway. But regardless, the landlord has to have the same procedure for all tenants. If this written certification is requested, it has to be done in writing and dated. Simply providing the victim survivor with the certification form is not enough. And then the victim survivor would then have 14 days to provide the requested documentation. However, the victim survivor does choose which type of certification to provide. So it could be something from a court or law enforcement agency, a qualified third-party statement. There is the HUD 5382 self-certification form, which I find to be very intrusive, and I prefer the Law Help MN form a lot better because that HUD form is a lot. Or any other type of statement or evidence as allowed by the landlord. So that form is pretty simple to find. When certifying, a landlord can't ask for any additional information unless there is conflicting information. So conflicting information is when the landlord maybe has received information from the other tenant that there's something amiss. It can't be something that they maybe witnessed, thought, or saw, or something along those lines. It has to be conflicting information that they've received.
It has to be like in an official capacity. It can't just be that the other person goes and says, I didn't do it, they did it. You know, it can't be like that. It's more like when we have both tenants maybe submit the VAWA notice. Sorry, I cut you off, but the VAWA notice, you know, landlords like to sometimes put their own knowledge or try to investigate or whatever when someone gives a VAWA notice, and that's not appropriate.
Yeah, thanks. That was much more clear. So yeah, that is the only time that they can ask for additional documentation. And then the victim survivor has 14 days to do so, whatever that might look like. And then similar to 504B is that there is a confidentiality requirement. And it has to be pretty strict. They can't share anything, of course, can't break that confidentiality, but they also can't document things, any of this information in the victim survivor's main file. It has to be kept separate. And it also can't be entered into any kind of shared database where other people have access. And that's pretty strong, I think. Those protections are really important for folks.
We're going to talk kind of briefly about the Fair Housing Act. The Fair Housing Act prohibits discrimination by direct providers of housing whose discriminatory practices make housing unavailable to persons because they are a member of a protected class. Victim survivors of domestic and sexual violence are protected under the prohibition of discrimination based on gender. And that's because the vast majority of domestic violence and sexual violence victims are people who identify as women. So this could be like this. The Fair Housing Act tells us that property damage caused by an abuser can't be charged to someone else, the victim. You know, we can't evict people because as a result of domestic violence, and that includes noise complaints and endangering the safety of others. It can also include non-payment of rent when a landlord charges a tenant, a victim survivor who's a tenant, for property damage that resulted from domestic violence. So we always look at those ledgers to see, like, because a lot of times the tenant will say, I've paid all my rent, you know, and it's because if we go back in the ledger, we see there was property damage charged. If that property damage charged was the result of domestic violence, that shouldn't have been charged. And then, like, giving a negative reference, that's a big one. That would be considered discrimination. If a landlord gives a negative reference that's based on their knowledge that the tenant was a victim survivor of domestic violence and that caused disruption or anything like that at the property.
Oh, hold on, we have a question. Is there a template out there that advocates can use to end the lease, but that also includes common things landlords can't do, and to be mindful of to eliminate them trying to punish the victim, break confidentiality, etc.? Some of that information is on the notice to the landlord, but there's not a ton of information there. I don't know of another template.
Yeah, and we have a draft notice letter on our website on the Standpoint Housing page, and I believe we included the confidentiality piece in that notice letter. The other thing you can do is show them the statute. It's all right there in the statute. And sometimes that's even better than a letter, right? To print out a page from the statute or send them a link to the statute and highlight that part. There is a new VAWA website. Here's some links for you. There's, you know, HUD is paying more attention to complaints for fair housing complaints and VAWA violations. So if you have a landlord, if you're working with someone who has a landlord who either charged for property damage or maybe locked them out or evicted because of domestic violence or whatever, you can file a complaint with HUD. That's not an immediate response. That's not like, how do we deal with this situation immediately? That's more of a long-term kind of slow process for an investigation. But, you know, we really hope to see more people filing HUD complaints on landlords who are violating these protections for victims of domestic and sexual violence.
And we do have another question as well.
Okay.
Can a landlord tell a tenant they have to move out if the cops come out for a domestic?
No. No. And we're going to get into that in a little bit, but no.
Oh, yes, sorry.
We're good? Okay.
Yep.
Let's do one of these and then we go forward.
Yep. All right.
Maybe
so
we can just throw the answers in the chat I don't know, we're kind of tight with time.
Yeah, you have so many good questions and we love it, but we're going to throw answers in the chat this time. So Hypo 8, Priya is applying for a Section 8 rental property. She recently divorced her partner due to domestic violence, which included financial abuse. As a result of this abuse she experienced, Priya has multiple large negative accounts on her credit history. The rental property has a policy against renting to applicants with a negative credit history. So the question is, can Priya's rental application be denied because of their negative credit history?
Anyone? Okay, we're going to say, I mean, it can be, right? But what Priya can do then is give a VAWA certification to say, to ask that the landlord doesn't, understand that this is a result of domestic violence, and then the landlord should take that into account.
Sweet. Sorry, we're kind of cruising through these hypos, but I think we can keep it moving. Keep going.
Do we want to do any of them?
We kind of have a lot to go, so maybe you're all asking great questions. You don't even need ours.
Yeah. So we're going to move on to talking about eviction. And one thing that we think really helps people think about eviction is that, first of all, eviction isn't the removal of someone from the property. It's a court process. So when we talk about eviction, that we're talking about the landlord has filed an eviction action with the court. Then in order for us to file anything with the court, right, we have to have legal grounds to do that. The legal grounds and legal grounds come from the law, right? So the legal grounds for an eviction action, there are 4. So anytime you're working with someone who says, I'm being evicted, and a lot of times by the time they're actually being evicted, they have a history with the landlord. And so a lot of things that have happened between the landlord and the tenant, and the tenant might come in thinking they're being evicted for all of these other things, right? And then we open up the case and it's a non-payment case. And when a non-payment case happens, all these other things that happen between the tenant and the victim are not really relevant. So whenever you're working with someone who has an eviction, go to MCRO and see if you can look up that case and look at the complaint, because the complaint has to state the legal grounds for the eviction. So again, we have 4. We have non-payment of rent, and that can be with a written or oral lease, right? And it can be even when the landlord has previously accepted late or partial payments. So non-payment of rent is about 95. Almost all the evictions in Minnesota are non-payment of rent. Then we have breach of lease. For a breach of lease eviction complaint, there has to have been a written lease, right? And the breach must be material. We call it material breach. It can't be minor. Having an unauthorized guest is a material breach. Disrupting the property is a material breach, unless it's the result of domestic violence. So it can't be something really small, like one day on one time their music was too loud, like that. That's probably a minor breach, and that is not something that someone should be evicted for. Then we have a holdover, and we talked about a holdover tenancy is when a tenant receives a proper notice and then they stay past that date. And then they become a holdover tenant. Now the landlord can go and evict for holdover. And then there's this provision that a landlord has to evict tenants who engage in certain illegal activity, including illegal drugs, illegal possession of guns, prostitution-related activity, possession of stolen property. But the stolen property had to have been acquired in a specific way, so that one is very uncommon. So we always want to start when we're talking about eviction. The first thing I go and look at the court papers to find out why is this person, from a legal perspective, why is the person being evicted? You're almost always going to see that it's non-payment of rent. The reason this is important is because each reason has a specific legal defense that we can raise. So in a non-payment case, for example, the only defense is almost always is come up with the money. If there are repair issues, that can be raised as a defense to non-payment. But by and large, retaliation isn't going to apply. You know, when we talk about holdover cases, retaliation could be a defense. So if that notice was given within 90 days of the, or 3 months of the tenant asserting their legal rights, then there's a presumption of retaliation. If the notice was invalid, so maybe it wasn't in writing, maybe it didn't have the right information in it, maybe the notice period, maybe they gave a 30-day notice and instead of 1 full calendar month notice, those notices would be invalid. When a landlord accepts a payment after giving a notice to vacate, and after like that end date has passed, that can be a defense, because then we would argue that by their actions, the landlord showed that they no longer wanted to be bound by that notice. The legal defenses for a breach of lease cases, there's no written lease. The breach was not material, or if the landlord accepted rent after the breach. So if I'm a tenant and I had a party last summer and it was really loud and chaotic, and maybe there was even property damage, like maybe it was a big deal. If I lived there for 3 or 4 more months and the landlord accepted rent from me, you know, then we can argue that the landlord waived his right to terminate or to evict on breach of lease for something that happened months ago. The defenses for the illegal activity is that it didn't happen. So landlords have to prove these things, right? And the defenses, it didn't happen. And then when the tenant didn't know or could not prevent the illegal activity, then that can be a defense too. And then medical marijuana, now the law has changed to around the new marijuana laws in Minnesota. But generally speaking, if it's illegal drugs, then you will be evicted for it.
Is there anything we should know about?
List of defensive, sorry. There are others, right? But we just want to point out that you need to have a reason, and then each reason has its own specific defenses. And so the first thing to do is find the reason.
And is there a difference with marijuana use and federally funded properties?
Yeah, you can't. You have to follow whatever the property's law rules are. Thanks for pointing that out. Here's some other miscellaneous defenses. You can't be evicted as a result of domestic abuse, criminal sexual conduct, sexual exploitation, or harassment. If the tenant vacated the property prior to an eviction hearing, technically that eviction should be dismissed, because the eviction is about possession of the property. If a tenant no longer has possession of the property, there's nothing for the court to decide. Improper service, although the rules around service has changed, so service is easier now. But for non-payment of rent cases, the defense is that the tenant paid, that maybe the late fees exceeded the statutory limit of 8%. Maybe there was no written lease. You can't have late fees unless it's in a written lease. Improper utility charges, repair issues, and then property damage that for charges that relate to domestic or sexual violence. And again, this is not a full list of the defenses. So if you're working with someone and they're being evicted, definitely give me a call and I'll review the case with you. Retaliation, Minnesota statute says the landlord cannot retaliate. We talked about this a little bit. Landlord cannot evict or terminate for police calls for safety or emergency. So if the police are being called to protect because of the emergency of the tenant, then you can't be evicted for that. If the police are being called for other things, then you can be evicted for it. But all residents in Minnesota, whether you're a tenant or otherwise, have a legal right to call for help. The thing about retaliation is it's a defense to an eviction. So the eviction has to be filed first. And then whenever anything is filed, there's a risk. We don't know what the court is going to say. You know, we hope that the court would see this situation the way we do, and that's assume and assess that the landlord is retaliating, but they may not. So the retaliation thing, it is a defense to an eviction, which means that eviction record already exists. Homeland has a good retaliation notice letter. You can check that out if you need it. Anywhere again, Minnesota statute 504B.205 says the residential tenant has the right to call the police or emergency personnel for help. A landlord cannot retaliate. You can't be evicted for this. Even in the cities that have crime-free ordinances, a landlord cannot use the crime-free ordinance to evict or charge a tenant for, or you can't have penalties or anything because Minnesota statute says you have a right to call for help. Again, if law enforcement is called for other reasons, there could be a problem. So we want to talk a little bit about the timeline for an eviction. Before the beginning of this year, the timeline for an eviction was very fast. For non-payment cases, we've added the 14 days to it because now for a non-payment of rent case, the landlord has to give written notice before they file an eviction. It's a pre-eviction notice. And again, it's only for non-payment cases. So it doesn't apply to breach or holdover. And the language required in the pre-eviction notice is very specific. The statute has it all written in there. And the other thing about the pre-eviction notice that's nice is that the pre-eviction notice can be used as proof of hardship for emergency assistance. Before we had to wait till a lot of places made the tenant wait until the eviction was filed, and now the tenant has an eviction record. Knowing emergency assistance is going to come in and pay, and the tenant's going to be able to stay. Now we have this pre-eviction notice qualifies as that proof of emergency for emergency assistance. So if the tenant doesn't get paid up within 14 days, then the landlord can file the eviction complaint. At that point, it is on the tenant's record, and a lot of times the tenant doesn't know. Then the tenant is usually served between days 1 and 7. This timeline was how it was every single time before COVID. COVID has kind of, changed this in some areas, in some courts, where the dockets are full, the court is waiting before they issue that summons because it just, the court date might be several weeks out into the future. The thing about the summons and complaints, the notice of the hearing has to be given within at least 7 days before the hearing. So then on the day of the eviction hearing could be 8 through 14. Again, this timeline is different post-COVID. And when you have an eviction hearing, it's technically an initial appearance hearing, but be prepared to have, tenants should have all of their evidence, everything they're going to try to show, because the trial could happen right there. If the tenant requests a trial, the court could say, okay, show me what you have. And it could just happen. So we need to be prepared with any kind of proof that we're going to bring at that initial eviction hearing. And then at the eviction hearing, if the court orders an eviction, the court could order that person to be removed from the property immediately. The court can, the tenant can always ask for time, as much time as possible before having to move out. And we have what's called a redemption period. So if the court orders, gives the tenant 7 days to move out, that's the most that the court can do in most situations. If the tenant pays and stays or pays in full within that 7 days, the landlord has to accept it and they stay. We call that the redemption period. And that's good in a lot of cases and for a lot of reasons, but that eviction remains on the record. So here's that new statute about the 14-day pre-eviction notice. Again, it's non-payment cases only. That written notice is required, and it has the specific information. It needs to be delivered personally or by mail. Then we're talking, they changed the laws around what must be included on an eviction complaint. We won't go through this too specifically, but for these non-payment cases, the payment ledger has to be attached and it has to be accurate. We have so many cases where they attach, maybe if they attach a ledger, by the time we get to court, it's a totally different number. The copy of the rent lease needs to be there. The copy of that pre-eviction notice needs to be, all that needs to be attached to the complaint. And then there's these things for other cases. But anytime you're working with someone who is has an eviction file, definitely give me a call and we can go through the case
All right, so as an advocate, if you're working with someone who's facing an eviction, we just saw the timeline, and while it's not 100% accurate post-COVID, it still moves really fast, especially when you're working with someone who needs to find new housing. So if someone has received that eviction summons and complaint, or depending on the type of case, the 14-day pre-eviction notice, you're going to want to, once the complaint is filed, take a look at it, find out the reason for eviction, make sure that all of the documentation is attached, like the ledger, the lease, all of that sort of thing. Dive into the ledger. Sometimes it takes a couple of brains to figure out the ledger. I'm not going to lie. Ann and I talk about these all the time. They're very confusing and math is hard. But if you look at that ledger, you'll want to see if there's any charges that resulted from domestic violence, if anything was inaccurate, if the tenant is like, wait, what the heck is that? I don't even know what that is. Because sometimes we don't know. We didn't know that something was charged to the ledger or whatever. So look through that. In a breach of lease case, get more specifics. Get information about what happened, talk to the tenant, look at the lease to see if it's actually in the lease as prohibited. And again, was whatever that breach was listed as the result of domestic violence? And if so, excellent question for Ann to talk through. And then holdover cases, I don't see them too often, but find out if the notice to quit was in there as well. And it's nice now that all this documentation has to be included in the complaint because it's just right there and you don't have to go calling the landlord a million times to try and get it. So dive into the paperwork that you're provided with. Look for inaccuracies, things that are related to domestic violence, and kind of figure out what's going on there and talk to the person you're working with. Talk to that victim survivor and figure out what's going on. Like Ann mentioned, there might only be a couple of reasons that someone can actually be evicted, but the tenant is going to give you more context. And they're probably going to have some pretty big feelings about it. They might be losing their housing. It gets pretty scary. So in those situations, know your resources, know legal aid if they're providing representation, know Ann's phone number, look into those sorts of things. And the biggest thing is to be best friends with anyone who has money to help people get caught back up on rent. So be very, very kind to those folks, whatever those agencies are, have good communication with them, because sometimes it does just come down to money. Money helps with so many things, obviously. So know those people and be very kind to them and start reaching out to resources sooner rather than later. And again, it moves super quick.
There is a question about the lease break. When following the notice to end lease due to fear of violent process, assuming that the victim survivor tenant advocate submitted the notice to the landlord correctly, what are the victim survivor tenant's options if the landlord refuses to accept the lease break and doesn't break the lease for the victim survivor?
We get that question a lot, actually. And they can't do that.
Move out. You give them the paperwork and you go. And this is where landlords might turn around and file an eviction later. And then if they do that, when I work with victim survivors, I'll write them a script of what to read in court to get the case dismissed. This is another reason why we really like those notice and the notice and the qualified third party statement to be given via email, so that if the landlord says, nope, I'm going to evict you instead, we have the proof that the landlord was given the notice. But this isn't something a landlord is even accepting. There's no accept or deny with this. The law says that the tenant can do it, and that's it. When you're working with people, if they're experiencing that, you can call me and I can write the landlord a letter to try to just, inform them of what the law says and stuff like that too. Otherwise, you can also try showing them the statute and say it's not something that you can deny.
Yeah, that statute, sometimes emailing that statute right over, highlighting the important bits about this is literally how it works. Too bad.
Yeah.
Be a good place.
Yeah, I think the Attorney General, landlord tenant handbook that's out there also, is pretty clear about it too. So that's another resource that some landlords consider to be legit. And this is just kind of a repeat of what we talked about. Eviction is the court paperwork. It's not the actual. Most evictions don't result in a tenant being removed from the property, right? Most evictions end up with the tenant paying, and there's a payment plan and a settlement agreement, and the tenant pays and stays. But those records remain. So that's a tricky one. And again, that notice to terminate, that's not an eviction.
And quick question for you before we get into this piece. If someone maybe is being evicted for non-payment of rent and doesn't have the money, can't get the money to pay up, should they still go to court?
Always go to court. When you get a summons and complaint, the court is summoning you to court. Like you can't just, well, obviously we can, but we shouldn't just choose to not go. And the other thing you go, a lot of times you'll end up with a settlement agreement. But if not, you can ask the court for as much time to stay, before the writ is issued, things like that. But it always looks better, even when we're thinking about expungement too down the road, if you don't default at a hearing, because when you just don't show up, the court, and just technically legally, like you're being summoned by the court, so they should go. And we do have new eviction expungement laws starting this year. We have a lot of mandatory eviction expungement that a lot of us tenants' rights people are pretty excited about. So automatic expungement, where the tenants don't even have to ask for it, it should just be automatic, is when the tenant wins the case. If the case is dismissed for any reason, when the parties agree to an expungement, or when the eviction was ordered 3 years ago. And so this is automatic, it happens. And because this is the thing, last year giving this thing kind of training, we would say that eviction record happens, even if you go and you pay and you stay, that remains on your record. And here we're saying, if you get a settlement agreement where the parties agree to expungement, then it will be expunged by the court. Then in previously, if a tenant wins a case, if they fight it and go to trial and they win, that they still have an eviction record. Or when sometimes the plaintiffs don't show up, sometimes the landlords don't show up, or the landlord withdraws the case or things like that. Or maybe the tenant pays the landlord, and then the landlord's like, okay, don't bother, I'll take care of it at court, don't bother. The tenant would think, okay, then I don't have an eviction on my record, but they're surprised to learn that they actually do. And so now, beginning in January of this year, those kinds of situations, the court will automatically expunge them. We also have mandatory expungement for when a tenant files upon motion, for when the case has a settlement agreement and the tenant fulfills the terms of that agreement. And then if the tenant could receive automatic expungement under criminal code for certain drug offenses, or if that breach was based solely on the possession of marijuana. So there are some mandatory expungements, but for those, the tenant still has to file the expungement motion. So this is just for you all to have. This is like the current law, or well, last year, and the new law. So this kind of just shows the difference there.
And with that, we are at 11:29, and we had extremely high hopes that we had so many hypos and a whole game at the end, and we have used up all of our time. So thank you all so much for your questions. We can certainly stick around if folks have questions that they wanted to ask. We are here because we had so much more to talk about, but that's okay. We didn't really get to play the game, and that's okay. We'll just be silly. So thank you all so much for coming. Thanks for your questions and engagement, and we're always here for you. And we'll just keep answering questions as they come in. So we have a question: if the landlord refused to accept the lease break, and then kept charging rent, and the tenant kept paying the rent, does that change things since the tenant kept paying rent?
Yeah. If a tenant, that's terrible. If a tenant gives a notice to vacate and to terminate the lease, but then they keep making payments after that date, then they're kind of showing that they didn't mean for that notice to continue.
And then would the tenant potentially be owed that rent to be refunded to them that was paid after they broke their lease?
So I think this one, if we could probably do a conciliation court claim and try to say that the landlord needs to give that back. The landlord's defense could be, well, I thought they took the notice back because they kept paying. But this one is, yeah, that's very, if you're dealing with that, call me and let's talk it through. and conciliation court, it never hurts to try.
You want to put our contact information slide up?
Yeah.
Okay, close your eyes quick if you
don't look. I know, I'm so disappointed.
I know. That's okay. Here's our contact information. We're always able to answer questions, talk things through, kind of brainstorm a bit. We went through some of the stuff kind of fast, and some of it's kind of new. So always know that you're welcome to call. Yeah.
I think we're done for today.
Perfect. And never be sorry for questions. Always ask them. That's literally why we're here and why we do these. So we're glad that those questions would be were answered, and always know that you can call with more.
Still questions coming in.
When will the recording be available? When we get it uploaded to YouTube. So in a few days, probably. That sounds about right.
Yes.
Great. Well, thank you all so very much. Have a wonderful rest of the day and call us anytime.
Thank you. Have a great rest of the day.